One of the main questions I'm asked during an initial consultation is, what are my entitlements? I like to call this the bullseye on the dartboard that then becomes the centre of negotiations between the parties. Put simply, provided you can satisfy a court that it is appropriate to make an adjustment of property, which is not an automatic right, there are 4 steps. Number 1, the court looks at the assets, liabilities and superannuation of the parties. Assets can include things that have a monetary and sentimental value, and it includes all assets acquired prior to the relationship, during the relationship and post-separation. Secondly, the court looks at the contributions of the parties to the asset pool. Contributions can be financial, such as mortgage repayments or the payment of living expenses, gifts or inheritances. They can be non-financial, such as a renovation to a property, or they can be homemaker or parenting contributions, such as where one person stays at home and looks after the children. Those contributions are considered equally important. The third step is that a court looks at the Section 75(2) factors, or what we like to call future needs. Future needs of the parties can include things such as age, health, income capacity, child support, and the care of children under 18. Essentially, the court looks at the future needs of the parties to determine whether one party's future needs are greater for the property pool that exists. If one party's future needs to the property pool are greater, that person will receive a swing their way. For example, if they are the lower income earner or they have primary care of the children. And the lower income earner would get an adjustment, particularly if their income ability has been impacted by the relationship. Now, I like to give the analogy of a pizza. If the parties' contributions to that pizza, including financial, non-financial, homemaker and parent, are equal, then the parties should consider that they have half of the pizza each. Then the court looks at the future needs of the parties to determine whether one party's future needs are greater than the other. And if they are, that person receives an extra slice of the other person's pizza to compensate. The fourth step is that the court looks at the overall outcome to determine whether the percentage split and the actual division of the assets is just and equitable. For example, it wouldn't be fair if one party only received the liquid cash assets and the other party received only superannuation. That concludes my talk in relation to how a court makes a just and equitable division of assets. I'm Courtney Barton, and if you're separating or thinking about separating, please don't hesitate to get in contact with me to book a reduced rate consultation and have a confidential discussion about your individual circumstances. Let me help you finalise your financial matters at the least possible financial and emotional cost.